Hello everyone, welcome back to the Legal Prudent Study channel. In this video, we'll cover the three topics of the fifth semester due LL.B, Faculty of Law, University of Delhi. So, in fifth semester, business regulation is an optional subject for the fifth semester students. So, in the first part of this series, we have covered the two topics of your syllabus, and in this video we will cover the three topics, and in the third part we will cover the remaining topics of your syllabus. Let's have a look on syllabus. The topics 3 talks about the Surface Act, that is the securitization, reconstruction of the financial assets, and the enforcement of the Security Interest Act 2002, Surface I in short. सो इस वीडियो में हम जानेंगे पहले कि द सिक्योरिटाइजेशन एक्ट सिक्योरिटाइजेशन रिकंस्ट्रक्शन एंड फाइनेंशियल एसेट्स एंड द सिक्योरिटी इंटरेस्ट, इन सारे टर्म्स का मीनिंग क्या होता है फॉर द पर्पस ऑफ सरफेसी एक्ट्स, एंड इसके ऑब्जेक्ट को जानेंगे व्हाट इज द मैकेनिज्म टू रिकवर द डेब्ट इन केस ऑफ द डिफॉल्ट if the borrower unable to pay the loan whatever in lieu of the loan he or she has deposited or in language गिरवी रख दिया है कोई भी एसेट्स को, तो फाइनेंशियल इंस्टीट्यूशन और बैंक उसको इन्फोर्स करके ऑक्शन करके अपने डेप्ट जो दिया हुआ है ब्रोवर को उसको रिकवर कर सकता है। द रेलिवेंट प्रोविजन जानेंगे, सेक्शन 13 उसके बारे में बात करता है। सो सारे प्रोविजन जो इम्पोर्टेंट है फॉर द पर्पस ऑफ योर एग्जामिनेशन and for the purpose of the securitization and reconstruction of financial assets and the enforcement of the Security Interest Act 2002 in short Surface Acts, हम relevant provision को जानेंगे। And the guys, a point to be noted that in SO examination the special officer of in banking, so the Surface Act is very important for the purpose of the SO examination of the bank, so that will be also covered, and the brief introduction will cover of the Surface Acts. So let's start. So the Surface Acts, what is the objective and the background of the Surface Act? The Surface Act is defined as an act to govern securitization and the reconstruction of the financial assets, as well as enforcement of the security interests, and to provide for a centralized database of the security interest formed on the property rights and the issue associated with or incidental thereto. उन तमाम issues जो भी in the process of this act सारे govern करता है. The Surface Act has the two main objectives: the recovery of the financial institutions and the bank non-performing assets, and in the timely and effective manner, and it's allowed the financial organization and the banks to sell the residential and the commercial assets at the auction of the borrower default on his or her debt. So the Surface Acts provide the following recovery channel for the recovery of the NPA, that is non-performing assets. The first one is reconstruction of the assets. So what does it mean? It is defined under the section 2(1)(b) of the Act. It can be accomplished by taking over the operation of the borrower's business, reconstruction the borrower's management of his or her firm, selling or leasing a portion or all of the borrower's business. The debt payment schedule has been scheduled, putting the security interest into action, entering into a debt settlement agreement with the borrower. So these are the few examples by which the reconstruction of assets can be accomplished. Now, the term securitization, what does it mean? It's defined under the Section 21Z of the Act, the practice of the creating the marketable securities supported by a pool of the potential asset, such as auto or house loans, is known as the securitization. Now, the third one is the enforcement of the security without the intervention of the court. The SARFAESI Act empowers the banks and the financial institution to enforce its securities. The process commences by the 60 days notice period to the debtor who has taken the loan from the financial institution, to the banks, to pay the due amount. On the failure to pay the said outstanding dues within the said statutory period, given power to the banks and the financial institutions to enforce its security interests by the initiating the following steps. So what are the steps? The bank and the financial institution has the right to take over the possession of the said security property, secured properties which has been given or secured by the bank in lieu of the loan, and this secured property is of the borrower. So the bank will take the possession of your secured property in case of default. The second one is the bank or the financial institution has the option to deal with such property by sale, lease, or assign the right over the said security. So the bank has the power, the financial institution has power, आपके जो सिक्योर्ड प्रॉपर्टी है उसको सेल कर सकता है, लीज पे दे सकता है और असाइन कर सकता है किसी और को to recover the debt. And the appointment of manager to the manage the said security also would be done. And it can approach the debtors of the borrower company for the realization of the borrower's dues. The act does not apply to the rural regional banks, nationalization banks, etc. I'm not sure about the State Bank of India, so I'm not talking about that. So forget this part. So now come to the definition clause. Assets reconstruction under section 21B. The assets reconstruction means the acquisition by any assets reconstruction company of any right or interest of the any bank or the financial institution in any financial assistance for the purpose of the realization of the such financial assistance. The assets reconstruction company meaning of under section 21BA, the assets reconstruction company meaning a company registered with the Reserve Bank under the section 3 for the purpose of the carrying on the business of the assets reconstruction or the securitization or both. What is the meaning of the center registry? Center registry has been defined under section 21G of the Act. Center registry means the registry set up and the cost to be set up under the section 2 under section 20 subsection 1. The meaning of the default is very important because in case of the default, the securitization, the process of enforcement of the security assets commence. So default under section 21J, the meaning of the default is the non-payment of any financial debt or the interest thereon on any other amount payable by a borrower to any secured creditor, consequent upon which the account of such borrower is classified as non-performing assets in the books of the account of the secured creditor in accordance with the creditors or the guidelines issued by the Reserve Bank. So the non-performing assets has been defined under section 210. Non-performing assets mean an assets or the account of a borrower which has been classified by the bank or the financial institution as substandard, doubtful, or lost assets in accordance with the direction or under the guidelines re- relating to the asset classified classification issued by the bank. So the meaning of the non-performing asset is very important, has importance to know this object of the act. So qualified institution buyer, now the qualified buyer, which is defined under section 21U. Qualified buyers means a financial institution, insurance company, bank, state, financial corporation, state industrial development corporation, trustee, or the state's reconstruction company, which has been granted a certificate of the registration under section 4 of the 3, section 3. So the what is the meaning of the borrower? 21F. The borrower means any person who has been granted financial assistance by any bank or the financial institution. Section 21K defines the financial assistance, means any loan or the advance granted or any debenture or bonds subscribed or any guarantees given or letters of the credits established or any other credits facility extended by and the bank or a financial institution. So what is the meaning of the reconstruction company? Section 21B of the Act defines the means. It means a company formed a registered under the Company Act for the purpose of the assets reconstruction. Section 21ZC defines the secured assets, means the property on which the security interest is created. So these properties belongs to the borrower initially and uh, has been now in possession to the concerned financial institution in lieu of your money given by the financial institution to the borrower, and the interest has been created. So the secured creditor, who is the secured creditor, which has been defined under the section 21ZG. The secured creditor means any bank or financial institution or any consortium or group of the bank, financial institution, and includes debenture trustee appointed by the bank or financial institution. So who is entitled to give the loan to the borrower is known as the secured creditor. इन शॉर्ट बैंक होते हैं, जो फाइनेंशियल इंस्टीट्यूशंस होते हैं, जो लोन्स वगैरह देते हैं, उनको सिक्योर्ड क्रेडिटर बोला जाता है. ओके. Who is the secured debt? Means a debt which is secured by any security interest. What is the meaning of the security interest? Which is defined under 21ZF. Means rights, title, or interest of any kind whatsoever upon the property created in favor of any secured creditor, and includes any mortgage charge, hypothecation, assignment other than those specified in section 31. So now come to the section 13 of the Act, which talks about the enforcement of the security interest. Section 13, enforcement of security interest. Subsection 1, notwithstanding anything contained in section 69 of the and section 69 capital A of the Transfer of Property Act, any security interest created in favor of any secured creditor may be enforced without the intervention of the court or tribunal by such creditor in accordance with the provision of this act. So the provision of this act must be followed in case of the enforcement of the security interest under section 13. The subsection 2 talks about where any borrower who is under a liability to the secured creditor under a security agreement makes any default in the payment of the secured debt or any installments thereof, and his account in respect of such debt is classified by the secured creditor as non-performing assets. As non-performing assets, then in that case, the secured creditor may require the borrower by notice in writing to the discharge in full his liability to the secured creditor within 60 days from the date of the notice, failing which the secured creditor shall be entitled to exercise all or any of the rights under the subsection 4 of this section 13. Subsection 3, the notice referred to the subsection 2 shall give the details of the amounts payable by the borrower in the secured assets intended to be enforced by the secured creditor in event of the non-payment of the secured debts by the borrower. So, subsection 4 talks about in case of the borrower fails to discharge his liability in full within the period specified in subsection 2, that is the 60 days, the secured creditor may take the recourse to one or more of the following measures to recover his secured debt, namely the first, the, take the possession of the secured assets of the borrower, including the rights to transfer by way of the lease, assignment, or the sale of the realization of the secured assets. The second, takes over the management of the business by the borrower. Appoint any person known as the manager to manage the secured assets. Require at any time by the notice in writing any person who has acquired any of the secured assets from the borrower, from whom any money is due or may become due to the borrower, to pay the secured creditor. So now come to the section 17, which talks about the application against the measures to recover the secured debt. Now under section 13 it talks about the enforcement of the secured assets, security interests. In case of the agreed person not happy with the measures taken by the financial institution, they can file an application under section 13 before the DRT, that is Debts Recovery Tribunal. So what is the procedure? What is the provision talking about? So section 17, application against the measures to recover the secured debt. Any person including the borrower aggrieved by any of the measures referred to the subsection 4 of the section 13 taken by the secured creditor, that is the bank or a financial institution or his authorized officer under this chapter, may make an application along with the such fees as may be prescribed to the DRT, that is the Debt Recovery Tribunal, having jurisdiction in the manner within the 45 days from which the date on which the such measure has been taken. So यहाँ पर 60 days notice मिलता है ब्रोवर को by the financial institution, and in case of not compliance by the borrower, the secured creditor has entitled to recourse the security interest, and after recourse the borrower may file an application under section 17 before the DRT within the 45 days of the notice of the such measures actually. So subsection 2 of section 70 talks about the DRT shall consider whether any of the measures referred to in section 13 subsection 4 taken by the secured creditor for the enforcement of the security are in accordance with the provision of the act and the rule made thereunder. If the debt, if DRT tribunal after examining the facts and circumstances of the case and the taken by the secured creditor are not accordance with the provision of this act and the rule made thereunder, and the required registration of the management and the registration of the possession the secured assets to the borrower or the aggrieved person, it may by order declare the recourse to any one of the measures referred in section 13 subsection 4 taken by the secured creditor as invalid in case of the non accordance with the act, and it can be restored the possession of the secured assets or management of the secured assets to the borrower or such order aggrieved person. who has made an application under subsection 1 of section 17, and the clause subsection 3 C talks about the pass such order direction as it may consider appropriate. So subsection 4, if the debt DRT declares the recourse taken by the secured creditor under section 13 clause 4 in accordance with the provision of the act and the rules made under then the notwithstanding anything contained in any other law for the time being in force, the secured creditor shall be entitled to take the recourse to one or more measures specified under it of the to recover of the debt. So any application under section subsection 1 shall be dealt with the debt DRT as expeditiously as possible and disposed within the 60 days from the date of which the application made. Provided that it may be DRT may from time to time extend the said period and not more than 4 months, which cannot be exceed 4 months. Okay. So the provision of this DRT, the function of DRT dealt with the provision of the recovery of the debts due to banks and financial institution Act 1993 and rules made thereunder. Section 18 talks about the appeal to the appellate tribunal, and the it is the provision in case of the appeal before the tribunal, the 50% of amount of debt due from the borrower need to be deposited with the appellate tribunal, and the appellate tribunal may reduce such amount to the 25% if there is a reasonable reason for the reducement. So section 19 talks about rights of the borrower to receive the compensation and the cost in certain cases when the secured creditor is taken measure which is not complies with this act. In such cases, the compensation would be awarded to the borrower. Okay, so section 34 is important, which talks about the civil court not to have jurisdiction. No civil court shall have jurisdiction to entertain any suit or the proceeding in respect of any matter which a debt recovery tribunal or the appellate tribunal. Now come to the some acts which and their objects. The SURFACE acts. The object is the security को enforce करना. ठीक है? Security interest को enforce करना. अंडर सेक्शन 13 में उसका प्रोसीजर दे रखा है. That is the recovery of the debts due to banks and financial institutions 1993. The object of this act is the recovery of the banks and the finance, the DEBT recovery by the banks and the finance. Companies Act 2013, liquidation and winding of the companies. Presidency Sound Insolvency Act and the Prevention Insolvency Act 2016 for the sickness and the insolvency of the partnership fund and individuals. Now the previous question and the count and then after the cases. एक क्वेश्चन है प्रीवियस ईयर का 2022 का. विजन इस्पात लिमिटेड took a loan from the Khera company cooperative Gramin Bank and offered the rights in one of the production plants as the secured interest to debt. Later on, here the borrower has offered the rights in one of the production plants as secured interest. So this is the secured assets. So Later on, the Vision Ispat made a default in payment of the loan and was declared as non-performing assets. The cooperative bank enforced the security interest under Section 13 of the SAFESI Act and took over the possession and the appointment of a manager to manage the secured interest. The Vision Ispa challenged the challenge before the DRT, that is the Debt Rents Recovery Tribunal, the action of the bank, and argued that the cooperative bank is not a bank for the purpose of the SAFESI Act, and the provision of the act are not applicable on the cooperative banks. The DRT decided in the favor of the cooperative bank. The Vision Ispat appealed the order of the DRT to the appellate tribunal. The appeal was not entertained as the Vision Ispat Limited did not deposit the 50% of the debt amount, which is a prerequisite. The Vision Ispat challenged the validity of the SAFESI Act before the Supreme Court on the ground that under the Act that the banks can enforce the security interest without any judicial determination, as the Act bars the jurisdiction of the civil court. The provision of the Act cannot be applied on a cooperative banks as it is a cooperative society having sub-banking function. The compulsory deposit of the 50% amount of the debt to entertain an appeal before the appellate tribunal is unreasonable and the arbitrary condition decided with the help of the precedents. So the first case is Mardia Chemical Limited versus Union of India and others, 2004 Supreme Court. The fact of the case is the Industrial Development Bank of India, that is IDBI in short, issued a notice to the Mardia Chemical Limited on July 24, 2002 under the Section 13 of the Act. Then the current ordinance, the requiring to pay the amount of arrears indicated in the notice within 60 days. The failing within which the IDBI has a secured creditor would be entitled to enforce the security interest without the intervention of the court or the tribunal, using all or any of the measures contained in section 13 subsection 4. The petitioner was also prohibited from selling, leasing or otherwise transferring any assets of the secured assets. The constitutional validity of the SAFESI Act was challenged in the particular section 13, 15, 17, 34 on the basis that these sections are unreasonable and arbitrary. So the petitioner argued that the recovery of a debt due to the Financial and the Financial Institution Act was sufficient to address the difficulty created by the NPA, that is non-performing assets, and that the current statute was unnecessary. The current statute is the SAFESI Act, which argued that it was unnecessary. The petitioner contended that Section 13 gave all the right to the banks and the financial institution and neglects the rights of the defaulters. Section 30 did not take borrowers' interest into account at all. Moreover, there was no rights of the representation or adjudication mechanism that could be upheld by the borrowers. Section 17 clause 2 subsection 2 stated that 75% of the amount, before the amendment it was 75% of the amount had to be deposited by the defaulter in order to prefer appeal or application. Amount was too much and the hence restricted access to judicial recourse of the appeal. It was like an implied bar had been created. Section 15 dealt with the procedure for the taking over the business and management of the entity, especially a company. Section 34 was the perimeter to the RDB Act, that's RDB Act, which stated that DRTs has exclusive jurisdiction, that is the bar on the civil code. The issues before the court were the following. The first one is whether it was open to challenge the SAFESI on the ground that it was not necessary to enact it in the prevailing background. and particularly when the another statute was already in operation. Whether the section 13 of the act was ultra vires the constitution, whether section 17, particularly section 17 subsection 2, is unreasonable and arbitrary, therefore violative of the constitution. The the what are the observation and decision of the court? Section where the secured creditor has taken action under section 13 subsection 4 of the act, in such cases it would be open to the borrower to file appeal under section 17 of the act within the limitation as prescribed, that is the 45 days. Within 45 days of such measure, the borrower has rights to file an appeal before the debt recovery tribunal DRT within 45 days. The Supreme Court upheld the act's constitutional validity, noting that certain provision of the act may be a bit harsh for some borrowers, but on the ground that the impact provision of the act cannot be said unconstitutional, for the very fact that the object of the act is to achieve the faster recovery of the dues declared as NPA, that is non-performing assets, and for the better availability of the capital liquidity and the recourse to help the growth of the country's economy and the borrowers. The requirement of the deposit of 75% of the amount claimed before the entertaining an appeal a petition under section 17 of the act is oppressive, onerous and arbitrary condition against all the canons of the reasonableness. Such a condition is invalid and is liable to be struck down. The Supreme Court determined section 17 subsection 2 of the act is arbitrary and ordered that the hearing be altered. The heading to be altered from appeal to application. पहले अपील था, राइट टू अपील सेक्शन 17 में, अब उसको एप्लीकेशन कर दिया गया है, which was came into force on 2016, 1/9/2016. What is the conclusion? Section 13 now states that the bank must evaluate all of the borrower's representation and they respond within the 7 days, which was later changed to the 15 days. Within section 70, the word appeal was replaced by the application. In 2016, the appeal was superseded by the application, an application in the marginal head. Delhi rent tribunals now have jurisdiction over the rights of the tenants in the security property. In such instances, the property is given to the person who files the application if he meets the requirements. Section 18 was also considerably amended. When the filing an appeal with the DRAT, you must deposit 50% of the total cost, which can be lowered to the 25% if things reasonable. The Delhi debt rents recovery tribunal was likewise granted a similar waiver right under the section 70. Therefore, as per the above discussion, in order to entertain an appeal, the Vision Ispat Limited, that was the borrower in the question given, needs to deposit 50% of the debt amount, and the same is not arbitrary in nature. The next case is Pandurang Ganpati Chowgule versus Vishwasrao Patil Murgud Sakari बैंक लिमिटेड. सुप्रीम कोर्ट का केस है 2020 का. इस केस को डिस्कस करने से पहले हम पढ़ेंगे बैंक का मीनिंग क्या है अंडर दिस एक्ट. द बैंक मीन्स ए बैंकिंग कंपनी, a corresponding new bank, the State Bank of India, a subsidiary bank, or a multi-state cooperative bank, or such other bank which The central government may by notification specify for the purpose of this act. Fact of the case, the Pilan challenged the Biswas Rao Patil Murgut Sahkari Bank Limited's action under the SARFAESI Act before the civil judge. In deciding the primary issue, the trial court determined that it lacked the jurisdiction to hear the case. The first appeal filed was denied, and against the said, the appeal has been filed with this court. A supplementary petition challenge under Article 13(2) of the Constitution has been filed, disputing the scope of the SARFAESI Act by cooperative bank sending notification under Section 13. So, issue was whether the provision of the Section 2C 4A of the SARFAESI Acts on the account of the inclusion of the multi-state cooperative banks and the notification dated at 28 January 2003 notifying the cooperative bank, the state are ultra virus. Whether the cooperative banks at the state or the multi-state levels are the subject to the provision of the Act. It was held that the Parliament has the legislative competence under the entry 45 of the List 1 of the 7th Schedule of the Constitution to provide the additional procedures for the recovery under Section 13 of the Securitization and Reconstruction of Financial Assets Act with respect to the cooperative banks. To cooperative banks, the provision of the Act, Section 21C4A of the SARFAESI Act, adding ex abundati cautela, which means safe side. To be the safe side, a multi-state cooperative bank is not ultra vires as well as the notification 21st January 20th January 2003 issued with respect to the cooperative banks registered under the scheduled state legislation. A five-bench, a five-judge bench of the Constitution of the Supreme Court, Constitutional Bench of the Supreme Court of India, ruled that the cooperative bank created by the cooperative society should be recognized as the bank under the SARFAESI Act. So the last case is Arts Polymer Private Limited versus Miss Alpine Pharmaceutical Private Limited. In this case, the appeal was preferred by the Miss Arts Polymer Private Limited, who had purchased the property from the original auction purchaser, namely Baba Chandramouli, and by the company. The borrower approached and filed a petition before the DRT and challenged the enforcement proceeding in respect of the subject property, including all the steps taken rise from the issue of the notice under Section 13, Section 13, Subsection 2 of the SARFAESI Act. The DRT Hyderabad dismissed the borrower's application, holding that the bank had followed the prescribed procedure under the SARFAESI Act, and the sale was valid. The Supreme Court also opined that the borrower does not object to the action of the creditor and accept the favorable decision from the creditor, then the later borrower would stop from the taking the inconsistent position to gain the advantage through the judicial proceeding. It was observed that the mere failure of the creditor in giving reply to the objections raised by the borrower, though otherwise considered, does not invalidate the SARFAESI proceeding. Finally, Supreme Court held that the order passed by the DRT confirming the procedure and the sale of the subject property under the Act was valid. It was upheld. बैंक ऑफ बड़ौदा वर्सेस कारवा ट्रेडिंग कंपनी 2022 का केस है. The borrower is served then with the notice under section 13 clause 2 subsection 2 of the Act requesting a particular quantity of money. The bank took the symbolic possession of the immovable property and sent the notice accordance with the 13 subsection 4. The bank published a notice of the public auction for the sale of the residential property. The issue involved the appellant claimed that the DRT decision in favor of the bank violated the section 13 subsection 8 of the SARFAESI Act. The Supreme Court held that the borrower cannot be freed from the total responsibility due unless and until the borrower is ready to pay the complete amount payable including the charges and expenditures with the secured creditor. Furthermore, it is held that a bank cannot be barred from the disposing of the mortgaged property at the public auction and the reading the proceeds and the recovery the remaining debts until the borrower's deposit pay the total amounts due payable as well as the fees paid by the secured creditors in accordance with the section 13. Forget about section F, section 13 of the SARFAESI Act. So time to time the amendment was made to this SARFAESI Act. Now come to the next topic, the Prevention of Money Laundering Act 2002. We have done with the SARFAESI Act. Now come to the PMLA Act 2002. We'll cover the recent cases also. The several cases has been taken place, but the few cases which will be covered for the purpose of your examination. So, what is the objective behind the PMLA Act? The Prevention of Money Laundering Act was enacted by the Parliament to prevent the money laundering and illegal financial activity. The PMLA helps to maintain the integrity and financial system and the country financial stability by placing the regulatory responsibilities on reporting organization and giving the authorities extensive power. The PMLA also allows the confiscation of the property that is involved in the money laundering. Need for the combating the money laundering. What is the need? The PMLA aims to combat illegal money conversion, where the illegal obtained money is disguised as white money. The common laundering method include hawala and trade-based laundering. The PMLA requires the banks to maintain the transaction records and verify the client identities, and it gives the authority to like the enforcement directorate the power to investigate adjudicating the authorities determine it properties are involved in money laundering. The objectives of these acts to prevent and control the issue of the money laundering, to confiscate or take into the custody any property that is likely to derive from or has involvement in case of the money laundering, to penalize the offenders with the offense of money laundering which has been given under section 4 of the Act, for the appointment of the adjudicating authority and the appellate tribunal for taking a charge of the matter related to the money laundering, to make it obligatory for the banking companies and the financial institutions and intermediaries to preserve the records and documents relating to the financial transaction, to manage any other issues related to the money laundering, magnitude of the money laundering, its accept and the various methods has been discussed. covered. So now come to the definition parts. For the purpose of these money laundering acts, just skip the Prevention of Money Laundering Act 2002. The definition clause, the money laundering defined under Section 3 and 21P. The Section 21P of money laundering of the PMLA Act defines the money laundering. It says it has meaning assigned to it in Section 3. The definition of money laundering is exhaustively covered under Section 3 of the Act of the PMLA. Section 3, offense of money laundering, whosoever directly or indirectly attempts to indulge or knowingly assist or knowingly is a party or is actually involved in any process or activity connected with the proceeds of the crime, including its concealment, possession, acquisition, or use and projecting or claiming its attend property shall be guilty of offense of money laundering. Punishment of the money laundering under Section 4. The punishment of money laundering, whoever commits the offense of the money laundering shall be punished with the rigorous imprisonment for a term which shall not less than 3 years but which may extend to 7 years and shall be also liable to fine, provided that the proceeds of the crime involved in the money laundering to any offence specified under paragraph 2 of the part A of the schedule. The provision of this act shall have effect if it's the word which may extend to the 7 years, the words which may extend to 10 years. So अगर पैराग्राफ 2 ऑफ द शेड्यूल पार्ट ए का अगर कवर करता है मनी लॉन्ड्रिंग, देन द पनिशमेंट will be 10 years, extend to 10 years. The enforcement of attachment, section 5 talks about. Section 5 talks about the enforcement, the attachment of the property involved in the money laundering. The survey and seizure and the search. Section 16 talks about the power of survey. Section 17 talks about the search and seizure. Section 18 talks about the search of the person. Section 19 talks about the power of arrest of the individual. Section 8 talks about adjudication under the Act by the adjudicating authority. If any complaint is filed under Section 5, Clause 5, Subsection 5, or an application is made under Section 17, Clause 4, or Section 18, Clause 10, the individual allegedly said to have been guilty of the committing the offence of the money laundering and will be served with a notice of not less than 13 days asking him to submit the proof of the source of from where the income, earning and the shares were obtained and provide the reasonable justification for why the property must not be impounded. Section 43 to 47 talks about the special courts. So by central government there will be a special court established for the purpose of the money laundering acts for the trial with the consent of the concerned chief justice of the states. The offence trial by the special courts for the punishment under section 4 shall be by the special court constituted for the area in which the offence has been committed. Like the Rose Avenue Court has the jurisdiction to detain the PMLA Act if the money laundering has been done. So offence to be cognizable and non-billable. Section 45 is important. It talks about the twin condition, and on this section, the, there are two cases has been discussed in this video. So section 45 talks about the the condition for the bail. Notwithstanding anything contained in the Code of the Criminal Procedure, now the Bharatiya Nagrik Surakshha Sanhita 2023, no person accused of an offence under the section under this act shall be released on bail or on his own bond unless the public prosecutor has been given an opportunity to oppose the application for such release, and where the public prosecutor opposes the application, the court is satisfied that there are reasonable grounds for the believing that he is not guilty of such offence and that he is not likely to commit any offence while on bail. So these are the twin conditions for the granting bail under the PMLA Act for the offender. Now come to the vesting power of the central government as per the section 9. The vesting power in central government where an order of the confiscation has been made under this act, all the rights and title in such property shall vest absolutely in the central government free from all encumbrances. Okay. The prevent Now come to the question and the cases. Question 5 of the 2022 previous year question. Tilak was an accused under the section 17 of the Narcotics, Drugs and the Psychotropic Substance Act 1985. Later on, the ED registered a case under the Act of the PMLA. During the investigation, the director ordered to attach the property without filing any complaint before the court for the taking cognizance of the scheduled offence under the PMLA Act. Director also ordered that the bank to freeze the accounts maintained by him. Tilak was to challenge the ED case as violation of the Article 20 Clause 2 of the Constitution, which talks about double jeopardy, as well as the complaint procedure as contemplated by the Act, has not been adopted by the Director. Whether the registration of the case under the PMLA Act violates the Article 20 Clause 2 of the Constitution, discuss the requirement of a valid attachment order under the Act, whether the directions given by the ED to banks to freeze the account is lawful, explain with the help of the decided case law. Also discuss the adjudicating procedure and the power adjudicating officer under this Act. Section 5, Section 8 need to be discussed in detail. So the first case is Rose Valley Real Estate versus Union of India of 2015, Calcutta. Go. Appellant number one is a public limited company which belongs to the Rose Valley group of the companies. The appellant number one had collected a sum of the 12.82 crore by the issuing non-convertible debentures from members of the public during the year 2001 to 2005 and 2008 without the filing proper documents either to the register of the company or the SEBI. Over the aforesaid issue, the SEBI issued the summons dated ITNA under the section 11C clause 3 of the SEBI Act, which talks about the investigation procedure, calling upon the plant number one company to furnish the information and document with regard thereto. Finally, an adjudicating process was initiated and by order dated 26 March 2013, the appellant number one was held guilty of non-compliance with the provision of the Act and monetary penalty of the 1 crore was imposed on it. In appeal, the Secretary Appellate Tribunal modified the penalty and reduced to the 10 lakh. In meantime, the criminal proceeding being case was filed before the learned Chief Judicial Magistrate, Calcutta, for the violation of the Section 12A, read with Section 24 of the SEBI Act, against the appellant. It appears that the said proceeding has been challenged before the court, and the same has been stayed. In pertaining, it is the pertinent to note that the offence under the Section 24 of the SEBI Act is a schedule offence under the PMLA Act 2002. With reference to the aforesaid schedule offence, investigation was initiated by the respondent number 3, that is educating officer, against the appellant under the provision of the PMLA Act. The ECIR number was that. So पीएमएलए में ईसीआईआर नंबर होता है, जबकि अदर एक्ट में का बात करते एफआईआर रजिस्ट्रेशन किया जाता है, लेकिन पीएमएलए में ईसीआईआर नंबर एज केस रजिस्टर्ड किया जाता है. So in connection with the such cases, investigation officer conducted search at the offices of the appellant and seized the money to tune of the 37,0763.50 rupees. Apart from the compact disc and the document, the appellant challenged the search and seizure, and the same was returned. The respondent authority issued show cause notice on the appellant, calling upon to him to the cause before the adjudicating authority as to why the seized property be no be not retained under the section 17 clause 4, read with section 8 clause subsection 3 of the PMLA Act 2002. On this date, the aforesaid cause notice was challenged by the appellants on the ground that there was no jurisdiction to initiate proceeding against the appellants under the provision of the PMLA Act. The appellant filed a reply to the so-called notice wherein the appellants raised the issue of the non-applicability of the PMLA Act and the jurisdiction of the authority to invoke the same. In the meantime, the deputy from here the main issue was arose. In the meantime, the Deputy Director of the Enforcement Directorate, the respondent number 3, herein issued the impugned letter dated 19 November 2004 upon the syndicate bank requiring the letter to prohibit, freeze and withdrawal from the accounts maintained in the branches of the said bank by Rose Valley Group of the company with the immediate effect. The appellant challenged the impugned letter dated 19 November 2014 issued by the respondent number 3 upon the respondent bank requesting them to prohibit, freeze or withdrawal from the accounts maintained in the branches of the said bank by the Rose Valley Group companies with the immediate effect. Investigation is defined under the section 21NA of the Act. Investigation includes all proceeding under the Act conducted by the director or by an authority authorized by the central government under this Act for the collection of the evidence. Court observed and made the following decision. The impugned letter dated 19 November 2014 issued by the respondent number 3 is to be read as the indispensable temporary measure for the reservation of the evidence pending investigation and has been issued in aid of the proceedings for the attachment and the seizure contemplated under the section 5 or the section 7 of the Act, not to the supplant them. Such incidental and the consequential power being in aid to the proceeding contemplated under the Act is held to be vested in the investigation agency in the view of the inclusion of definition of the investigation under section 21A of the PMLA Act. Respondents banks being the reporting entities under the Act are duty bound to assist the investigation agency in terms of the section 54 of the PMLA Act, and therefore the insurance Issuance of the notice upon the respondent's bank cannot be said to be illegal. Failure to refer other scheduled offence apart from the one of the SEBI acts in the impugned letter would not ipso facto invalidate the same in the view materials emanating from the records of the investigation as also the saving provision engrafted in the section 68 of the Pimle Act. Impugned letter dated 19 November September having been held to be the temporary measure in aid of the proceeding under the Act and cannot be in itself. Hence, the appeal was partly allowed. As per the facts given in the question number 5, Tilak cannot challenge the ED case as violation of the Article 20 Clause 2, the Constitution of India, as he has been charged under the two different crimes and not the same crime. Section 17 of the NDPS Act states about the punishment for the contravention in relation to the prepared opium, whereas the Prevention of Money Laundering Act, he has been charged for the proceeds of the crime directly or indirectly. Thus, both are the different of the offence. Therefore, it is clear that the offence of the money laundering is proceeded by the commission of a scheduled offence, and the proceed of which they become a subject matter of the offence of money laundering. Scheduled offence are listed in the part A to C of the schedule to the Act and includes offences under the various statutes such as the Indian Penal Code, Prevention of the Corruption Act, Security of the Exchange Board of the India Act, Companies Act, and etc. Next case P. Chidambaram versus Directorate of the Enforcement. Supreme Court's judgment. It's also known as the INX Media case. In case the appellant, that is the P. Chidambaram, then the Home Minister, former Home Minister, has challenged the order dated 15/11/2019 of the Delhi High Court, which rejected the anticipatory bail of the appellant in the INX Media case involving the alleged irregularity in the Foreign Investment Promotion Board clearance given to the INX Media for the receiving foreign investment to the tune of the 305 crores against the approved inflow of the 4.62 crore rupees. A FIR registered by the CBI under section 120 capital B read with 420 of the IPC Act, section 8 and section 13(2) read with section 13 clause 1D of the Prevention of Corruption Act against some unknown suspects with allegation that the Miss INX Media Private Limited, accused number 1 in the FIR, sought for approval of the Foreign Investment Promotion Board for the permission to issue by way of the preferential allotment. On the basis of the aforesaid FIR, the respondent Directorate of the Enforcement registered a case under Section 3 of the PMLA Act against the accused mentioned in the FIR. The appellant was not named as an accused in this case as well. The Supreme Court in the case of the Gurbaksh Singh Sibia versus State of Punjab clarified that the position of the Section 438 of the Code of Criminal Procedure Code of the Criminal Procedure CRPC 1973, the Supreme Court held that the High Court and the Court of the Session have a wide discretionary power to grant the anticipatory bail, as it is necessary right for the individual to presume innocent until the proven guilty. Further, the Supreme Court also issued certain guidelines to be followed by the court while exercising such power. The observation and decision of this case, it was observed that there is not a flight risk and there is no possibility of the tempering the evidence and in influencing or intimidating the witness. Taking these and all the facts and circumstances, including the duration of the custody, into the consideration, the plaintiff, in our considered view, is entitled to granted bail. it is made clear that the observation contained in touching upon the merits either in the order of the High Court or in this order shall not be construed as opinion expressed in on merit, and all the contention are left upon to be considered during the course of the trial. For the purpose above, the order was passed as follows. The instant appeal is allowed and the judgment 15/11/2019 passed by the High Court in bail application impugned herein set aside. The appellant is ordered to be released on bail subject to the executing the bail bond of 2 lakh rupees. The passport of the was deposited and it was ordered to not leave the country, and all the requirement under section 438 should be followed. Nikesh Tarachand Shah versus Union of India. In this case, the section 45, the twin condition was challenged, and the Supreme Court unanimously struck down the aforesaid provision on the ground that it violates the Article 14 and 21 of the Constitution. Later in the case of Vijay Mandal Chaudhary and others, the observation of the Nikesh Charachand was not accepted. We'll come to the later after 2 minutes. In between, we'll discuss the case B. Rama Raju versus Union of India. In this case, where the Andhra Pradesh of the High Court held that the intention of the legislature behind the provision to the Section 15 5 Clause 1 was clarified that there are two sets of the proceeding provided for the acts, a criminal action and a civil action pertaining to the attachment of the confiscation, and a criminal action whether the offence of money laundering is made out. So, Ram Jethmalani versus Union of India 2011, the fact that several writ petitions have been filed by the KPS Gill, Ram Jethmalani, etc. under the Article 32 of the Constitution seeking the formation of the special investigation team for the investigation and prosecuting the case related to the unaccounted money of the various individuals. The issue was whether the SIT can be formed by the Supreme Court for the bringing the black money from the fraud. The decision of the Supreme Court expressed the dismay over the attitude of the government of India and pulled the government for the not showing the seriousness in bringing the black money stated away abroad. The court rejected the contention of the government that since a high-level committee HLC is already set up, there is no need for the SIT. The court ordered to form the SIT must be formed. So last case on this PMLA is Vijay Mandal Chaudhary and others versus Union of India of 2022 Supreme Court. The Supreme Court upholds the constitutionality of the power of enforcement directorate for the arrest, search and seizure attachment. Court uphold the constitutionality of the reverse burden of the proof and twin condition of the bail. The expression investigation in clause any of the 2 of the Act does not limit itself to the matter of the investigation concerning the offence under the Act and is interchangeable with the function of the inquiry. Section 3 of the Act has a wider reach and captures every process and activities direct or indirect dealing with the proceeds of the crime. The provision in the form of the section 2045 of the Act is applicable post amendment 2018 and reasonable and has direct nexus with the purpose and object sought to be achieved. So, Supreme Court was not able to agree with the observation in the Nikesh Tarachand Shah distinguishing the enunciation of the Constitution Bench decision in the Kartar Singh and other provisions suggesting of the doubt of the perception of the parliament in regard to the seriousness of the offence of money laundering, including the about the posing serious threat to the sovereignty and integrity of the country. So we have covered the two topics, The first one, SURFACE Act and the PMLA Acts. Now come to the topic 6, the Essential Commodity Acts. It will take hardly 20 minutes or 15 minutes. This act was enacted to ensure the availability of the essential commodity to consumer and to protect them from the exploitation of the unscrupulous traders. Therefore, the Act provides the rules related to the regulation and the control of the production, pricing, and the distribution of the essential commodities. There are two main aims to this object: to maintain and increase the supply of these essential commodities, to secure equitable distribution and availability of these essential commodities to the consumers. Section 2, capital A, Essential Commodity Acts Declaration, etc. Essential Commodity Act, for the purpose of this act, the Essential Commodity Act means a commodity is specified in schedule. In schedule, there are approx 7 to 8 commodity has been described as essential commodities. So, subsection 2, subject to the provision of the section 4 of the central 4, the central government may, if certified that it is necessary to do so in the public interest for the region to be specified in the notification published in the official gazette, amend the schedule so as to add or add a commodity to the schedule. सेंट्रल गवर्नमेंट से पावर टू कम्युनिटी को ऐड कर सकता है. ओके. Remove any community from the said schedule in the consultation with the concerned states. Note: every notification issued under the subsection 2 shall be laid as soon as may be after it issued before the both houses of parliament. Section 3, power to control production, supply, distribution, etc. of the essential commodities. Section 3, under this section, the central government has power to issue the control order, and such order provide for the regulation and the prohibition of the essential commodities schedule in one of the following circumstances: when the government finds it is necessary and expedient to do so in favor of the public interest, when they have to secure the equitable distribution and availability of this commodity in the market, when they have to secure any specific commodity for the defense of India. Price control under subsection 3 of the section 3. When any person sells any essential commodity in compliance of the order made under section 3, the price of that essential commodity shall be determined as agreed price, controlled price, market price. Fixing of the price of the essential commodities during the emergency under section 3, subsection 3A. The central government, when the finds necessary to control the emergency situation, may issue a notification regarding the selling price of any foodstuff in any locality. Section 3, clause 5. An order made under this section shall, in the case of an order of the general nature or affecting a class of the person, be notified in the official gazette, and in the case of an order directed in the specified individual, be served on the such individual by delivering or tendering it to be individual. If it is cannot be delivered or tendered by the fixing it on the outer door or some other conspicuous part of the premises within the individual lives, a written report there shall be prepared and the witness by two persons living in the neighborhood. Section 3 subsection 6 talks about every order made under this section by the central government or by any officer or the authority of the central government shall be laid before the both house of the parliament as soon as may be after it is made. The schedule of the essential commodity acts covers the essential commodities: the drugs, fertilizer, foodstuffs, hand cans, wholly from the cotton, petroleum and petroleum products, raw jute, high jute textile, seeds of the foods, crops and seeds of the fruits and the vegetables, seeds of the cattle fodders and jute seeds. And note, in the wake of the COVID-19 outbreak, the mask and sanitizer also became the listed under the this schedule. So mask and sanitizer also become the essential community acts. What is the importance of the acts? The legislature has given the essential community has a special place by the placing it under the ninth schedule of the Constitution of India. Article 31B of the Constitution of India states that the act and the regulation specified in the ninth schedule shall not be deemed to be facts. And the essential commodity is the commodity specified under the schedule of the Act. The central government in the public interest is empowered to amend the schedule so as to aid or commodity or falling under the entry 33 in list 3 of the concurrent list in the 7th schedule to the constitution to the said schedule or remove any commodity from the said schedule in consultation with the concerned state. The Essential Community Act, one of the important laws of the country that applies for the protection of the interests of the general public. Under this act, the central government possesses a wide range of the power to control and production of the supply of the essential commodities. Under this act, the central government controls the price of the act, confiscated or the seized essential commodity. All these power are necessary to maintain the market. So, a Essential Commodity Amendment Ordinance Act ordinance was passed in 2020. The several changes was occurred. So now come to the previous year question of 2022. With the aim to maintain the supply of the drugs and to control and fair price, the central government issued an order under Section 3 of the Essential Commodity Act during the COVID pandemic as drug price control order. The said order was challenged on the ground that there is an unfair and arbitrary fixing of the price, as well as the unreasonable restriction has been applied by the government, which hampered the fundamental rights of the under Article 19(1)(g) of the Constitution of India. Thus, government argued that the Parent Act has been protected due to its placement in the ninth schedule of the Constitution, and the order made thereunder is also saved by the protection granted to the Parent Act, and its validity cannot be challenged. The second ground of the challenge was that the order was not laid down before the both of the House of the Parliament, which is necessary procedure. Being on the advocate of the drug manufacturer, argue your case with the help of the earlier decision. Now come to the case. Bragg, Ice and Isles Mills and another etc. versus the Union of India 1978 का case है Supreme Court. One question on the validity of the Mustard Oil Price Control Order 1977 issued under this act. A seven-member of the bench of the Supreme Court held as follows the constitutional validity of the price fixation under this act. The dominant purpose of this provision is to ensure the availability of the essential commodity to consumers at the fair price. And though the patent injustice to the producer is not to be encouraged, and reasonable return on the investment or a reasonable rate of the profit is not the sine qua non of the validity of the action taken in the furtherance of the power conferred by the subsection 3 subsection 1 section 3 section 1 and section 3 2c of the Essential Commodity Act. The interest of the consumer has to be kept at the forefront of the prime consideration that an essential commodity act ought to be made available to the common man at a fair price, must rank in the parity over the every other consideration. On the matter of the immunity under Article 13(1) capital B, the Honorable Court has held that the price control order is a mere creature of the Parent Act and is incidental and ancillary to it, and they cannot justify the protection of the ninth schedule being extended to it in claiming the Parent Act is incorporated in the schedule. However, the court, while holding there is no substance in the petitioner grievances that the price control order offends against the Article 1491F and 91G as held. The mechanism of the price fixation has necessarily to be left to the judgment of the executive, and unless it is patent that there is a hostile discrimination against a class of the operators, the the processual basis of the fixation of the price has to be accepted in the generality of the case as valid. Sri Meenakshi Mills Limited versus Union of India 1973, the validity of the Cotton Textile Control Order 1948 was challenged. The five members of the bench of the Supreme Court, while dealing with the issued under the Act, has held floors. The question of the fair price to the consumer with reference to the dominant object and the purpose of the legislation claiming the equitable distribution and availability of the fair price is completely lost sight of the profit, and the producers' returns are kept in the forefront. That the maintenance and increase of the supplies of the community or the equitable distribution and the availability at a fair price are the fundamental purposes of the Act. If the prices of yarn or the cloth are fixed in such a way to enable the manufacturer or the producer to recover his cost of the production and secure a reasonable margin of the profit, no aspect of the infringement of the fundamental rights can be said to be arise. In determining the reasonableness of the restriction imposed by the law in the field of the industry, trade for the commerce, it has to be recommended that the mere facts that some of those who are engaged in this are alleging loss after the imposition of the act will not render the law unreasonable. Sitaram Sugar Company Limited versus Union of India last case. The Constitution Bench of the Supreme Court deliberated as to who has power to fix the prices of the essential commodities. The court held that the question of the fixation of a fair and the reasonable price for the goods placed on the market has come for the consideration of the parliament and the court in different contexts. The price fixation is generally a legislative function, and but the parliament generally provides for the interference only at a stage where, in the pursuance of the social and the economic objectives or to discharge duties under the directive principle of state policy, control has to be exercised over the distribution and the consumption of the material resources of the community. The court concluded that while the parliament has enacted the Essential Commodity Act, it has left it to be discretion to the executive to take the concrete step to fixing of the prices of the Essential Commodity as when the necessary arises. By the promulgating the control order in the exercise of the power of the state in the Essential Commodity Acts. So we have covered the three topics, that is Surface Act, PMLA Act and the Essential Commodity Acts. In next video we will cover the remaining two or three topics. So thank you so much for watching this video. I hope this video will help you to enhance your knowledge, and in brief it has been covered your syllabus apart. So thank you so much for watching again, and if it's helpful for you, you all guys may subscribe this channel and press the bell icon and like this video, and you can also share to your colleague to help them. Thank you so much again. If you have any query, you can drop your query in the description box. You may also contact to me on Gmail rkg 32724@gmail.com, and you can also contact to me on my Telegram or Instagram. My Instagram or Telegram ID is Pudent Rahul. So thank you so much for watching this video again. Thank you so much.